Good morning, Madam Chief Justice, Your Honors, and may it please the Court. My name is Amanda Quinlan, and I represent the respondents in this case. Expectations of privacy and what people rely on to be outside the reach of government cannot be reduced to language in a contract. That is why this Court must reject any bright-line approach to Fourth Amendment standing. Today I will discuss with you 3 reasons why this Court should affirm the United States Court of Appeals' decision and find that Mr. Nightingale had standing to challenge the search of the rental car. First, expectations of privacy and determining those expectations involves a fact-bound inquiry, which the approach in the 4th, 5th, and 10th Circuits fails to provide. Second, by reserving and paying for the rental car, Mr. Nightingale had a possessory interest in that vehicle, sufficient to confer Fourth Amendment standing. Third,
did they ask him whether or not he wanted to drive the car?
the rental car company,
Yes.
Your Honor, the facts do not suggest one way or the other. However, it was he who reserved that rental car, and it was his friend, Miss Sparrow, who went to pick up the rental vehicle.
So he wasn't on the contract, even though he paid for it. I mean, every time I've gone to rent a car, they always say, "Will anybody else be driving this car?" No, I'm the only one signing it. How do we deal with the facts here that say that he has not signed the rental agreement, and we have case law that says unless he is the authorized driver of the vehicle, he has no expectation of privacy?
First of all, Your Honor, we do not know if Ms. Sparrow was asked whether or not somebody else should be on the rental agreement. We don't know if she simply signed her name. But to Your Honor's point about the case law on point, only 3 circuits have gone the route of looking for the bright line test, which is whether or not somebody is on the rental agreement to define whether or not they have standing. There's also other approaches. In the 8th and 9th Circuit, they rely on permission from the authorized driver. But the test we would have this court adopt is expressed by the 6th Circuit in United States v. Smith. And in that case, the court takes into consideration the totality of the circumstances and not just whether or not somebody's name is on the rental agreement. The court starts with a presumption against unauthorized drivers to have standing to challenge the search of rental vehicles. However, the court holds that if the totality of the circumstances show that a person had a legitimate expectation of privacy in that car, they can overcome that presumption.
In the Smith case, wasn't the person who actually signed the lawful renter was Smith's wife, and there he had in this case, we do not have a marital relationship between the lawful renter and the respondent.
That's true, Your Honor. However, the marital relationship is not the factor that the court points to. The court looks to the relationship as a factor to determine whether or not an individual has standing, but does not say that the marriage is the relationship that must be in place. What the court is really trying to do is to distinguish between cases like in Mitchell, where an individual hijacked a vehicle and had no relationship to the authorized driver whatsoever, and cases such as Smith, and in the present case, where there is a relationship between the individuals. Another instance where the relationship would be too attenuated to really weigh in defendant's favor for standing or in plaintiff's favor for a 1983 claim would be in Obregon, which is a 10th Circuit case. And in that case, a third party arranged the rental agreement, and it was not the person who gave the unauthorized driver permission. However, the court in Smith does not just look to that one factor. The court also looks to 4 other factors. The first is that the driver was licensed. In Smith and in the present case, both drivers were licensed drivers and weren't operating the vehicle illegally. The second is that the authorized driver was able to provide the rental agreement and the information on the rental car when asked to do so. And also that the individual had permission from the authorized driver to operate the vehicle. But the most significant factor that the court states is that the individual in Smith, as here does Mr. Nightingale, they both reserved that car under their own credit card, which the court said made him, in Smith, the de facto renter of the vehicle.
Counsel, why do any of these factors have anything to do with the reasonable expectation of privacy?
They have to do with that, Your Honor, because first of all, in this court's holding in Raucus, we look to whether or not an individual has an actual expectation of privacy, and also second, whether society would recognize that expectation of privacy. And looking to just the contract wouldn't fulfill what society believes is a legitimate interest or a legitimate expectation of privacy. Looking to whether or not somebody has a possessory interest in a vehicle, such as Mr. Nightingale in the present case, could show that society is willing to recognize that yes, he did pay for that car, he did have a right to be in there, and that's a legitimate expectation that he has. So it's more than just reducing it to the language of the contract. In fact, the Fourth Circuit, one of the circuits that has adopted the bright line approach, has shown its doubt as to whether or not this approach still represents society's legitimate expectations of privacy. And this was in the United States v. Houston, a Fourth Circuit case. And even the Fifth Circuit, another one of the three circuits that has adopted the bright line approach, there's a split within that circuit as well. The same year that the court adopted the bright line approach, the court in the Fifth Circuit in Kisu Lim also said that permission could be sufficient to grant Fourth Amendment standing.
There wasn't any permission here, though, was there?
Yes, Your Honor, there was permission, not necessarily explicit direct permission, but given the circumstances that Ms. Spera was under arrest and she was unable to communicate with Mr. Nightingale, and the fact that it would be absurd for her to deny him access to that vehicle and to drive that vehicle, considering he paid $200 on a security deposit there, and also $99 a day, and it would be him who would incur the late fees. We have to look to the totality of the circumstances to see that she did in fact give him permission, and a holding otherwise would be a little bit absurd given our commonsensical understandings.
But wouldn't it be absurd for her to let him take the car when she would have no way to get home? She was in a police station really far from home, right? Like hours and hours maybe?
Your Honor, we're not sure how far away from home she was, and we're not sure what the circumstances were of how they would return otherwise. However, given the fact that he wanted to return the vehicle and avoid those late charges, that's also a circumstance to take into consideration. The facts don't indicate how far they were, that there's no alternative means of transportation.
So, counsel, is there any reason to doubt the legitimacy of the original stop of the car?
Your Honor, there could be a reason to doubt that. However, because the facts point to, first of all, perhaps this was part of the security detail for the president, and then another set of facts, another page on the record indicates that this is for determining whether people were in an appropriate state to drive their vehicle. If we look to this court's holding...
Where's there reference to the state? I'm assuming you're alluding to sobriety? Any reference to that in the record?
No, Your Honor, there's not an explicit reference to sobriety. What they do reference in the record on page 4 is that they're looking to see whether or not people were in a condition to drive. However, then later on the record on page 4, they say that this was part of the president's security detail. And if we look to this court's holding in Edmond...
And counsel, was Mr. Nightingale driving toward or away from the event at which the president appeared, and did this happen before or after the event?
This was after the event, Your Honor. Therefore, if we're looking to that this is part of the security detail, this could be an impermissible stop. However, a stronger point for this court to deny that this was a search that violated the Fourth Amendment was that Officer Nahn, looking to page Romanet 4 and 5 of the record, only asked to search the vehicle, or didn't ask to search the vehicle, went right in to search the vehicle after learning that Mr. Nightingale was not on the rental agreement. She then felt like she had the unbridled authority to do so, which is exactly why this court should not adopt a bright line approach. Officers should be focused on whether or not they have probable cause to search a vehicle, and not on whether or not they can because of a technicality of somebody's name not being on the rental agreement. Holding otherwise does give police officers this unbridled authority to search rental cars when they don't necessarily have to or need to.
How could the officer's actions here offend the Fourth Amendment when the gun was in plain view?
Your Honor, the gun was not in plain view. Looking to page Romanet 4 and 5 of the record, we see that Officer Nahn noticed an object, and then she proceeded to rifle through the papers, the rental agreement and the driver's license, only when she noticed that Mr. Nightingale's name was not on the rental agreement did she ask him to step out of the vehicle. Had this been a situation where the gun was in plain view, she would not have hesitated to ask him to get out of the vehicle and to go in after that contraband. And under this court's holding in Illinois v. Andreas, for the plain view exception to apply, the nature of that contraband has to be immediately apparent. And again, looking to page Romanet 4 and 5 of the record, we see she only noticed a partially concealed object. She did not know that that object was in fact contraband. So the plain view exception cannot apply to this case.
If it wasn't a firearm, what else could it have been?
Your Honor, that's unclear. She said it was partially concealed under the passenger seat. However, and it would be speculation as to what that might be. And it's clear from the record that she only felt entitled to search once realizing that Mr. Nightingale's name was not on the the rental agreement. Further, by renting and paying for that car, Mr. Nightingale is not just the de facto renter of that vehicle. If we look to the Sixth Circuit approach, he has a possessory interest in that vehicle. And this court in Rock has held that a possessory interest in a space conveys a legitimate expectation of privacy, sufficient to convey a Fourth Amendment standing. And this court in Jones also held that the ability to exclude others from a space is definitely an interest that society would view as legitimate.
Any difference, counsel, between the car in this case and the public phone booth?
Your Honor, the public phone booth that you're alluding to from the decision in Katz would be a public area where the individual did not actually own the space. However, he still had an expectation of privacy. He himself believed that nobody could hear what he was saying except the individual on the other line of the payphone. And also, society would view that as a legitimate expectation, that you could close yourself in a phone booth and nobody would be listening to what you were saying. So that's the analysis here, and not necessarily whether or not the individual owned the car. So here, Mr. Nightingale himself did not own the car. However, he did have that actual expectation that this is his sphere of privacy. And also, it was legitimate for society to view that as a legitimate expectation of privacy as well.
So this court should be guided principally by Katz. Is that what you're arguing?
Yes, Your Honor. However, there's also an element of possessory interest here that could go towards the sort of trespass approach to the Fourth Amendment. There's nothing more possessory than putting money down on a vehicle. Again, page 2 to the appendix of the record shows a $200 security deposit. If something were to happen to that vehicle, it would not be out of Miss Sparrow's pocket that the money would go, or would come from, but it would be out of Mr. Nightingale's pocket. So that's a true possessory interest, in addition to the fact that he himself was returning the vehicle in order to avoid late fees. So this is his interest, and that is something that society, that our everyday expectations of privacy, we would view as legitimate. Furthermore, respondents contend that what petitioner puts forth is we need a clear-cut standard for police officers in the field. This defies the very purpose of the Fourth Amendment. First of all, we enforce the Fourth Amendment after the fact in a motion to suppress in a criminal case or in a Section 1983 claim for the court today. And it is not for the officers in the field to decide whether or not somebody has standing to get into the courtroom. That is an issue for the judges to parse through. And second, any issue of clarity of the law would go towards a qualified immunity defense, which the officers in this case waived much earlier in the proceedings by failing to raise it at an earlier time. Additionally, police officers should focus on whether or not they have probable cause to search the vehicle. There are already standards in place for the police officers to rely on to ensure that they're not violating constitutional rights of plaintiffs in Section 1983 claims.
Just so I can understand your argument, counsel, you're asking us to adopt the Sixth Circuit totality of the circumstances approach, even though the facts here are less favorable than they were in Smith, because Smith was not married to, in this case, we don't have the respondent married to the lawful driver. There's also no match of address on the rental agreement. And then you're also asking us to apply this implied permission. So you're asking us to take a lot of steps here, counsel. Why should we find in your client's favor?
First of all, Your Honor, the marriage issue, that is really just looking at the relationship and making sure the unauthorized driver doesn't have an attenuated relationship to the lessee. And here, Mr. Nightingale has known Ms. Sparrow for 6 years. They dated at one point in time as well. And further, the implied permission, in the 8th and 9th circuits, they use permission as a sort of proxy for whether an individual has consensual possession of the vehicle. And this is a clear-cut case where the plaintiff, the respondent, has consensual possession of the vehicle in that he put down a security deposit and $99 a day to rent the vehicle. We have to look to more than just the language of the contract when determining Fourth Amendment rights. And for those reasons, we ask this court affirm the Court of Appeals decision. Thank you.